If you're watching this video, you're probably at a crossroads. Contact with your child has broken down, informal arrangements have failed, and you're considering taking the mother to family court. The form you'll need is called a C100 application for child arrangements order. But before you fill it in, you need to understand what you're starting, when to do it, and what happens next. I'm going to walk you through the C100 application step by step. By the end of this episode, you'll know exactly how to complete it, what mistakes to avoid, and what to expect after you file it. This is Series 5, Court Procedure, Episode 21, the C100 application. Let's start with the most important question. When should you apply? You should apply for C100 when informal arrangements have completely broken down and there's no realistic prospect of a resolution without court intervention. That means contact has been blocked or severely restricted for weeks or months. Attempts to communicate have been ignored or met with hostility, and the mother is showing no willingness to facilitate contact. Here's what you should not do. Reply reactively after a single blocked weekend. Court is a last resort, not a first response to conflict. The conflict broke down yesterday, you're not ready to apply. Document attempts, send emails, try mediation, build your evidence base first. But here's the other side. Don't wait too long. Some fathers wait a year before applying, thinking they're showing restraint. By then, the status quo is solidified. Your child has adjusted to life without you. CAFCAS and the court will ask you why you waited so long if this is supposedly urgent. The sweet spot is typically 2 to 4 months of documented failed attempts at contact before applying. Now, the MIAM requirements. MIAM stands for Mediation, Information and Assessment Meeting. Before you can apply to court, you must attend a MIAM unless you qualify for an exemption. The MIAM is a meeting with a mediator who explains how mediation works and assesses whether it's suitable for your case. You'll attend alone first, then if you proceed, the mediator contacts the mother to invite her. If she agrees, you try mediation. If she refuses or if mediation breaks down, the mediator signs your MIAM certificate, which you need to file with your C100. Cost: typically £60 to £150. The mediator must be accredited. You can find one at familymediationcouncil.org.uk, but there are exemptions. You don't need a MIAM if there's evidence of domestic abuse within the last 12 months, the application is urgent because the child is at risk, the child's whereabouts are unknown, you're applying for enforcement of an existing order, or the mother is bankrupt or in insolvency proceedings. The domestic abuse exception is the most common. Evidence includes police involvement, a domestic violence protection notice, an ongoing criminal case, a domestic violence protection order, evidence from a GP or health visitor, evidence from a multi-agency risk assessment conference, or a letter from a domestic abuse support organisation. You don't need a conviction. Evidence that an allegation was made and investigated is enough. Here's the trap. Some fathers think they can claim domestic abuse exception by alleging abuse in the application. That's not how it works. You need documented evidence that pre-exists your C100. If you claim an exception without proper evidence, your application may be rejected or delayed while you attend a MIAM anyway. Now let's go through the C100 form itself, section by section. Section 1, about you, the applicant. Full name, date of birth, address, contact details, straightforward. But here's what matters. Use an address where you can reliably receive court correspondence. If you're sofa surfing or between addresses, use a trusted relative's address or a PO box. Missing court letters because you moved is catastrophic. Section 2, about the other people in the case. Usually just the mother. Her full name, date of birth, address. If you don't have her current address, write what you know and explain in Section 14 additional information that you'll provide it when known. Section 3, all about the child or children. Full name, date of birth, gender. If there are multiple children, list all of them. The court will make one order covering all children unless there's very specific reasons to separate them. Here's a common mistake. Fathers list the children's address as the mother's address and write lives with mother in the box. That's fine if accurate, but if you had shared care that was recently disrupted, write what arrangement was before breakdown and explain the current situation in Section 14. Don't concede the status quo in Section 3 if the status quo is recent and disputed. Section 4, parental responsibility. Do you have it? If you were married to the mother when the child was born, yes. If you're named on the birth certificate and the child was born after December 2003, yes. If you have parental responsibility order agreement, yes. Otherwise, no. If you don't have parental responsibility, you can apply for it on Form C1, which is alongside the C100. This is important. Parental responsibility gives you the legal right to be involved in decisions about your child's education, healthcare and welfare. Without it, you're fighting with one hand tied behind your back. Section 5. Urgent and without notice applications. Tick yes only if the situation is genuinely urgent, meaning the child faces immediate harm or risk of removal from the jurisdiction. If you're applying because contact has been blocked for months, that's not urgent in the court's eyes. Urgent means days, not weeks or months. If you tick urgent, you'll need to draft a separate urgent application explaining why notice cannot be given to the mother and why the court should act immediately. Unless you have very specific advice from a solicitor, leave this section unticked. Misusing the urgent process irritates judges. Section 6. This is where you specify what order you're asking for. The options are decide who the child lives with, decide how much time the child spends with each parent, or decide other aspects of parental responsibility. Most fathers tick spend time with and ask for child arrangement orders setting out contact. Be specific. Don't just write contact. Write what you're actually seeking. The child shall spend alternative weekends from Friday 6 p.m. to Sunday 6 p.m. with the father, and one midweek overnight from Wednesday after school till Thursday morning. Why be specific? Because vague applications like meaningful contact or regular time give you no negotiating position. The court and CAFCAS need to know what you're actually asking for so they can assess whether it's realistic. Don't ask for 50-50 shared care in your first application unless you genuinely had that arrangement before breakdown. Courts move incrementally. If you haven't seen your child in months, asking for equal shared care makes you look unrealistic. Ask for what's achievable, progressing contact from supervised to unsupervised to overnight to alternate weekends. Section 7. Details of the order. This is where you expand on Section 6. Explain what contact arrangement you're seeking and why it's in the child's best interests. Don't rant about the mother, focus on the child. For example, the father seeks alternate weekend contact and one midweek overnight per week. This will provide stability and routine for the child, allow the child to maintain a relationship with the father and paternal family, and reflect the child's established need for involvement from both parents. Keep it to a few sentences. Save the detailed arguments for your position statement. Section 8. Risk factors. This is Practice Direction 12J section. Tick yes or no for domestic abuse, child abduction risk, substance misuse, mental health issues, or other safety concerns. If you tick yes to anything, you'll need to provide details in Section 9. Here's the dilemma. If the mother has made allegations against you, do you tick yes under domestic abuse, even though you deny the allegations? Technically, yes. The question asks whether domestic abuse is raised as an issue, not whether it occurred. If allegations exist, tick yes and explain in Section 9 that allegations have been made but are denied. If you are alleging the mother has been abusive, tick yes and provide brief details. Don't write a dissertation. Write, the mother has subjected the father to controlling behaviour, including monitoring his location, isolating him from family and friends, and making threats to deny contact with the child. Then reference evidence you're attaching. Section 9. Safety concerns. If you tick yes in Section 8, provide details here. Keep it factual and unemotional. Date, events, evidence, no speculation or inflammatory language. Section 10. Attending court. Do you need special arrangements? Separate waiting areas from the mother. A hearing loop for hearing difficulties. An interpreter. Tick yes if needed and specify what you need. Section 11. International element. Does the child have any connection to another country? Passport from another country? Mother from another country? Property abroad? If yes, provide details. This affects the court's jurisdiction and risk assessments around abduction. Section 12. Litigation capacity. Can the other party participate in proceedings? Usually yes, only relevant if the mother has severe mental health issues or lacks capacity. Section 13. Declaration and signature. You're declaring that the information you've provided is true to the best of your knowledge. Sign and date. Do not make false statements in a court application. That's contempt of court and can result in criminal prosecution. Section 14. Additional information. This is your space for anything that doesn't fit elsewhere. Use it to explain. If you don't have the mother's full address but are making efforts to obtain it, if there are previous court proceedings involving the child, if there's relevant background about the breakdown of contact, if there are specific reasons you didn't attend the MIAM, keep it concise, a few paragraphs maximum. This is not your position statement. You'll have space to make detailed arguments later. Now, what documents do you need to attach? Your MIAM certificate, unless you're claiming an exemption, in which case attach evidence of the exemption. If you're claiming domestic abuse exemption, attach police reports, GP letters, or supporting organisation letters. Birth certificate for the child. If you're applying for parental responsibility, attach Form C1, any existing court orders relating to the child, evidence supporting your application, contact attempt logs, text message screenshots, emails showing block contact. Do not attach huge bundles of evidence at this stage. The court doesn't want 500 pages with your C100. Attach only what's directly relevant to establishing jurisdiction, exemptions, and the immediate basis for your application. You'll have the opportunity to submit detailed evidence later. How do you submit the C100? You can submit online through the MIAM CTS portal if you have an account, or by post to your local family court. Find your court at gov.uk/find-court-tribunal. Submit 3 copies, one for the court, one for the mother, one for yourself. The fee is £232 as of 2026. If you're on benefits or low income, you can apply for fee exemption using Form EX160. Don't let the fee stop you applying if you genuinely can't afford it. The exemption process is straightforward. What happens after you file? The court issues your application. Issuing means the court stamps it, assigns a case number, and sets a date for the first hearing dispute resolution appointment called FHDRA. The issued application and notice of hearing are then served on the mother. Service means formal delivery, usually by post. From the date of issue, the mother has 14 days to file an acknowledgement and, if she wants to contest or make her own application, to file Form C7. The C7 is the mother's response, setting out her position, raising any safeguarding concerns, and proposes her own contact arrangement if different from yours. Meanwhile, CAFCAS is notified. CAFCAS will conduct safeguarding checks, police checks, local authority checks, checks of any previous family court involvement. If there are safeguarding concerns, CAFCAS may contact both parties by phone before the first hearing to conduct initial risk assessments. The FHDRA usually takes place 6 to 8 weeks after you file. This is your first court hearing. At the FHDRA, the judge will identify issues, consider safeguarding, and attempt to reach agreement on interim contact arrangements. If agreement can't be reached, the judge will make directions, what reports are needed, what evidence should be filed, and when the next hearing will be. Common directions include CAFCAS to prepare Section 7 report, which is a welfare report assessing what contact arrangements are in the child's best interests. Fact-finding hearing if allegations of domestic abuse or serious issues need to be determined before final contact arrangements can be made. Filing of evidence and statements by both parties by specified deadlines. Interim contact orders. Temporary arrangements pending the final hearing. Let me tell you the most common mistakes fathers make on C100 applications, because these mistakes are entirely avoidable. Mistake 1. Applying too soon. You had one bad weekend where contact was blocked and you immediately file a C100. The court will ask you what attempts you made to resolve this. If the answer is none, I went straight to court, you look reactive and unreasonable. Document attempts first. Wait at least a month until there's genuine urgency. Mistake 2. Asking for too much too soon. You haven't seen your child in a year and you're asking for 50-50 shared care starting immediately. The court will see this as unrealistic. Build up gradually. Ask for what's achievable now with a pathway to more time later. Mistake 3. Using inflammatory language. Section 7 is not a place to call the mother a narcissist, or accuse her of parental alienation, or rant about her family. Focus on the child's needs and your relationship with the child. Leave the mother out of it as much as possible. Mistake 4. Not being specific. I want contact. Tells the court nothing. What contact? When? How often? Be specific. Alternate weekends? Midweek overnight? Holiday contact? Specific proposals can be negotiated. Vague proposals lead nowhere. Mistake 5. Submitting too much information. Fathers sometimes attach a 100-page bundle with every text message from the last 2 years. The court doesn't want that at the C100 stage. Attach only what's essential. The MIAM certificate, birth certificate, evidence of immediate relevance like recent contact denial. Save the detailed evidence for later hearings. Mistake 6. Not keeping a copy. You send off your C100 and don't keep a copy of what you wrote. Months later, you're in court and can't remember exactly what you said in your application. Always keep copies of everything you file. Mistake 7. Missing deadlines. The court sets deadlines for filing evidence, statements, and responses. Missing a deadline can result in your evidence being excluded or the case being decided without your input. Set reminders, file early, treat every deadline as non-negotiable. Mistake 8. Not reading the other side's evidence. The mother files a C7 response and you don't read it carefully before the hearing. You walk into court not knowing what her position is or what allegations she's made. Read everything that she files. Make notes. Prepare responses. So where does this leave you? You've filed your C100, the court has issued it, the mother has been served, your FHDRA is still in 6 weeks. What should you be doing? Firstly, comply with any directions already given. If the court has ordered you to attend MIAM or provide additional documents, do it immediately. Second, prepare for CAFCAS contact. CAFCAS will likely phone you before the FHRDA to conduct safeguarding checks. Be professional, calm and factual. Don't rant about the mother. Answer their questions directly. This phone call feeds into their safeguarding letter that goes to the judge, so take it seriously. Third, start drafting your position statement. Your position statement is a more detailed document setting out your case, what contact you're seeking, why it's in the child's best interests, your history with the child, your response to any allegations made by the mother. We'll cover position statements in detail in episode 24. Fourth, organise your evidence. If you're going to rely on text messages, emails, or other documents, get them organised now. Print them out. Put them in chronological order. Create an index. Don't leave this until the night before the hearing. Fifth, talk to other fathers who've been through this. Join both Parents Matter support groups. Read about other people's experiences. The process is less intimidating when you know what to expect. Let me leave you with this. Filing a C100 is the beginning of a process, not the end. The application itself is just paperwork. What matters is what comes next. Your preparation, your evidence, your conduct in court, and your ability to stay focused on your child's welfare rather than your conflict with the mother. Fathers who succeed in family court are the ones who understand that this is a marathon, not a sprint. You're not going to win everything at the first hearing. You're going to build your case incrementally, comply with every direction, and demonstrate over time that contact with you is in the child's best interests. This is the Family Court Uncensored series, episode 21. Next time we're covering the first hearing dispute resolution appointment in detail, what to expect, how to prepare, and how to make the best impression possible. See you then.